Welcome back to the deep dive. So today we're doing something a little different.
Yeah.
Usually we look at a specific event, maybe a trend, but today we're looking at the machinery itself. We're looking at the hidden operating system of the country.
Right.
We're talking about administrative law. And before you reach for the skip button, because that sounds like a lecture on, I don't know, filing taxes, stick with me.
It's not about paperwork.
No, it's about power.
That is the perfect way to frame it. It really is the code that, that runs the government. It dictates how this giant machine of the state interacts with you, the individual citizen.
Exactly.
And maybe more importantly, it defines what happens when that machine malfunctions or breaks a promise.
Or tries to crush the little guy. And
Oh,
to
yeah.
prove this isn't just dry theory, I want to start with a scenario from the source notes that, well, it feels like a total travel nightmare.
Okay.
I want you to imagine you're at a busy train station. It's loud, it's chaotic, you're struggling with a heavy bag. Right. You spot a man in a crisp porter's uniform, the official cap, the badge, the whole 9 yards. You catch his eye, hand him your bag, and he nods. He walks through the official staff barrier,
Uh-oh.
and then he just vanishes, steals the bag.
It's a classic con, but wow, a devastating one.
So naturally, you sue the railway company. You say, your employee stole my luggage. But then the railway drops a bombshell.
What's their defense?
They say, actually, that guy, he's a fake. He bought the uniform at a costume shop. We never hired him. He's not on our payroll.
Wow.
So technically, they say we aren't responsible.
And if you look at it from a strict employment contract perspective, the railway, they have a point.
They do.
If I didn't hire him and I don't pay him, why should I be liable for his crime?
That's the logical defense. But here's the question. Is the railway responsible? The answer lies in this legal concept called estoppel. And to help us decode that and the rest of this machinery, I'm glad you're here to walk us through these notes.
It's great to be here. And that railway case, I think it was Soanes versus London and Southwestern Railway from 1919. It's the perfect entry point.
It really is.
It introduces us to the first pillar of our discussion, the doctrine of estoppel. If I had to summarize it in, playground terms, it's the legal version of no backsies.
No backsies. I love that. Okay, so let's unpack the railway ruling. Why did the court side with the passenger if the porter was actually a fraud?
Because the railway created an illusion. They allowed this man to wear their uniform at their station.
Okay.
They let him walk through staff-only barriers. The court ruled that the railway was estopped, or legally prevented.
Blocked.
Exactly. Blocked from claiming he wasn't an employee.
So even though it was a lie, the fact that the railway let the lie happen means they have to pay for it.
That's it. It all comes down to representation. The notes break this down into 3 really strict conditions for estoppel to apply.
What are...
First, there has to be a clear representation, a signal from one party to another. In this case, the uniform and the access to the platform, that was the signal.
Okay, that makes sense. If he was just wearing a T-shirt, the railway wouldn't be liable.
Right. No way.
Mm-hmm.
The second condition is that the other person must have acted upon that representation. You handed over the bag specifically because you saw the uniform. You relied on the signal.
And the third?
Detriment. The action must have hurt your interests. Losing your bag is the detriment. So if those 3 things align, representation, action, and detriment, the law steps in and says to the railway, look, we don't care about the reality of your payroll. We care about the reality you projected to the public.
That's actually a really powerful tool for accountability. It forces institutions to be careful about how they appear, not just how they legally function.
It creates a duty of care, really.
You can't just turn a blind eye to someone impersonating your staff and then, shrug it off.
And it's not limited to trains. There's another fascinating case in the notes. Chegalal Keshavalal Mehta versus Patel Naradas Haripai. This one's from 1982.
Okay.
And it moves the concept from luggage to real estate.
What was the setup there?
It involved a tenant who had a non-transferable interest in a property.
Right.
So legally, he wasn't allowed to sell his lease or pass it on.
Right.
But he went ahead and sold it anyway. Took money from a buyer, acted as if he owned the rights.
Oh, wow.
Then later, when things got messy, he tried to argue, well, actually, that sale is invalid because I never had the right to sell it in the first place.
That is just incredibly brazen. I scammed you, therefore the contract doesn't count.
It's the ultimate gotcha, isn't it?
Yeah.
But the court used estoppel again. They said, you cannot deny your own title. You represented that you had the right. The buyer paid based on that.
So you've stuck with it.
You were stuck with the lie you created.
Hmm.
You were stopped from telling the truth now just to save your own skin.
I see. So estoppel effectively freezes the narrative at the point where the promise was made. Now, this brings us to the big question, and this is where administrative law really kicks in. Does this apply to the government? Because the government makes promises all the time. Policies, incentives, tax breaks. Can the state pull a backsies?
This is the heart of the matter.
Yeah.
This is what we call promissory estoppel. And the general rule is, yes, the government is bound by its word.
Generally.
Generally. If the government makes a promise intending for you to act on it, and you do act on it, they can't just flip the switch and say, never mind.
The notes highlight a really clear example of this, the woolen garments case. Union of India versus Anglo-Afghan agencies from '68.
This is a landmark case in Indian administrative law.
Yeah.
So here's the situation. The government wanted to boost exports to Afghanistan.
Right.
So they announced a scheme. They told manufacturers, if you export woolen garments, we will give you import entitlement certificates.
Just to clarify for everyone listening, these are basically permits that let a company import expensive raw materials cheaply. It's a massive financial incentive.
Huge. And the government promised the value of these permits would be equal to 100% of the value of what was exported.
Wow.
So Anglo-Afghan agencies said, deal. They ramped up production, they exported the wool, they spent the money, they did their part.
And then the government got cold feet.
Pretty much. When the company came to collect their permits, the government said, well, actually, we've decided to only give you partial concessions, not the full 100%.
They tried to move the goalposts after the game was finished.
Yes. You can't change the deal after the other side has delivered.
It feels fundamentally unfair.
That's exactly what the Supreme Court said. They ruled against the government. They said the government was estopped by its promise.
Because the company acted on it.
The company had altered its position, spent money and resources based on that government policy. The state had to honor the full amount.
That sounds like a massive win for the citizen. It implies the government can't just toy with businesses. But I'm looking at the limitations section in these notes.
Ah, yes.
And it seems like the government has some pretty significant escape hatches. It's not a blanket rule, is it?
No. And, realistically, it can't be. If the government could never change its mind, policy would be frozen forever.
True.
So there are three major exceptions where estoppel fails. First, and this is logical,
Yeah.
you cannot use estoppel to force the government to break the law.
Okay, so if a corrupt official promises me a permit to build a house in a protected forest, I can't sue to get it.
Correct. If the promise is against a statute, the promise is void. The law of the land trumps the promise of an official. Second, if you got the promise through fraud, obviously it doesn't hold.
Makes sense. And the third one, this looks like the controversial one.
The public interest exception. This is the government's trump card. If the government can prove that there's a changed situation or that public interest demands a change in policy,
They can break their promise?
they can.
That term public interest is doing a lot of heavy lifting there. Is there a case where they successfully use this to get out of a deal?
Yes. Kissaram Industries versus Union of India in 1977. The government had promised certain assistance to the company. Later, they withdrew it.
And the company sued.
They did, citing estoppel, just like the woolen garments case.
Oh.
But this time, the court sided with the government. They accepted the argument that executive necessity and the broader economic needs of the country had changed.
So the argument is, we promised you this money, but now the country's priorities have shifted, so the needs of the many outweigh the promise to the few.
That is exactly the logic. It's a balancing act. The court has to weigh the unfairness to the individual against the flexibility the state needs to govern.
It does make you realize that a contract with the government isn't quite as ironclad as a contract with your neighbor. The sovereign always keeps one hand on the escape hatch.
It's an asymmetric relationship for sure.
So we've established the rules of the game estoppel and its limits. But where do these fights actually happen? Because if I have a dispute with the government about my pension or something, I don't just go to the local civil court.
You could, but you probably wouldn't want to. We all know the state of the Indian judicial system.
Yeah.
Millions of pending cases, decades to get a verdict.
Right.
If every government employee dispute went to the high court, the system would it would collapse.
So we built a bypass road.
We built tribunals.
Yeah.
This was a major shift brought in by the 42nd Amendment to the Constitution. The notes specifically mention Articles 323A and 323B.
Let's parse those quickly. What's the difference between A and B?
It's a technical distinction,
Mm-hmm.
but it tells you who gets to use the fast lane. Article 323A is exclusively for public service matters.
Government employees.
Right. Article 323B is for everything else. Taxation, foreign exchange, land reform, food supply, that sort of thing.
Okay, let's focus on the employees first. The notes talk a lot about Sagada CCOT, the Central Administrative Tribunal. This is basically the HR department's Supreme Court, isn't it?
In a way, but with actual judicial power. It was set up under the Administrative Tribunals Act of 1985. If you're an IAS officer or you work for the central government and you're denied a promotion or your pension is short,
You go to get
you go to CAT. And the selling point here is speed.
an expertise.
Speed and specialized expertise. That's why they're called quasi-judicial. They aren't just run by judges. The panel includes a chairman, who must be a high court judge, but also administrative members.
Ah, so experts who understand how the bureaucracy actually works from the inside.
Precisely. Because a regular judge might know the law, but they might not understand the intricate, unwritten rules of government seniority lists.
That's smart.
And here's the biggest difference that the listener needs to grasp. CCAT is not bound by the CPC, the Civil Procedure Code.
For the non-lawyers, that's the massive rule book that makes regular court cases take 20 years, right?
Basically, yeah. The CPC dictates every specific form, notice period, and evidentiary rule. It's rigid. CCAT bypasses that. They were guided by the principles of natural justice.
That sounds very philosophical. Natural justice. What does that mean practically?
It's actually very simple. It means fairness. Two main rules. No one can be a judge in their own cause, and both sides must be heard. As long as those basic tenets are met, the tribunal can set its own procedure to get to the truth quickly.
It cuts the red tape. Who does this cover?
It covers all India services, Central Civil Services, and PSU employees. But the notes list some important exclusions. If you work for Parliament, the Supreme Court, or the Defense Forces, you can't go to CICI.
They have their own systems.
Their own separate hierarchies, yes.
And SAT is just the state version.
Exactly. State administrative tribunals. Same logic, just for state employees.
Now, there is another tribunal in the notes that I think is even more relevant to the general public, the NGT, the National Green Tribunal.
This is a big one. And the notes point out something I didn't realize until I read this. India is only the third country in the world to set up a dedicated environmental tribunal,
After who?
after Australia and New Zealand.
That's impressive. We beat most of the developed world to this.
We did. It was set up under the NGT Act of 2010. The headquarters is in Delhi, but they have circuit benches in Chennai, Kolkata, Bhopal, and Pune. This is where you go for civil cases on the environment, the Water Act, the Forest Act, the Air Act.
And just like CKT, they skip the rigid procedures. But they have some specific principles they follow. The notes mention polluter pays.
That's the core philosophy. It's not just about stopping the pollution, it's about restitution. If you damage the environment, you pay to fix it.
Right.
And they also use the precautionary principle, meaning if there's a risk of severe damage, lack of full scientific certainty shouldn't be a reason to postpone safety measures.
Better safe than sorry.
That's it.
And they have teeth. I'm looking at the famous interventions listed here. The 2017 plastic ban.
Huge impact. The NGT banned plastic bags less than 50 microns thick in Delhi. It fundamentally changed the retail landscape overnight.
And the Art of Living Festival case. This was a massive controversy a few years back.
It was. The foundation held a massive cultural festival on the Yamuna floodplains. The NGT ruled that the sheer footfall and construction damaged the delicate ecosystem. They slapped a penalty of 5 crores on them.
5 crores. That sends a signal that this isn't just an advisory body. They can hit you where it hurts.
Absolutely. And they aim to dispose of cases within 6 months. Compared to the decades it takes in civil court, that is lightning speed.
So tribunals are the doers. They decide, they punish, they enforce. But then we have this other category in the notes, commissions of inquiry.
Ah, yes.
And the distinction here seems vital.
It is the difference between a sword and a magnifying glass. Commissions are set up under the 1952 Act. They are fact-finding missions. The government appoints them to look into a definite matter of public interest.
Usually after a scandal or a disaster, right?
Right. And they look powerful on paper. They have the powers of a civil court to summon witnesses, seize documents, but, and this is a huge but, they cannot punish anyone.
They can't issue a sentence?
No. Their reports are purely recommendatory. They submit the findings to the government, and the government can choose to act on them, or they can choose to ignore them.
That explains why we often hear about a commission report gathering dust. The notes mention the Justice Lieberhan Commission.
investigating the Babri Mosque demolition. It took nearly 17 years to submit the report.
17 years.
17 years. By the time the report comes out, a whole generation has passed.
Wow.
And then you have the B.N. Sir Krishna Commission on Andhra Pradesh, or the Inquiry into the Kaleshwaram Project. These bodies are crucial for a historical record. They establish the truth, but they don't deliver justice in the sense of punishment.
That's for the courts and the tribunals.
Okay.
So if tribunals are the fast-track, commissions are the slow deep dive. And then we have the third pillar in our notes, public corporations. These are the bodies that actually run the business of the government.
Right. Think LIC, ONGC, the Damodar Valley Corporation. These aren't just government departments like the Ministry of Finance. They are statutory corporations.
Created by a specific act of parliament.
Yes. And the legal magic trick here is that they are given a separate legal entity. They can sue and be sued in their own name. They have autonomy to run like a business.
Without running to the minister for every signature.
Right. Hire people, manage funds, but they are still owned by the state. The government provides the capital and appoints the board.
And they are accountable through parliament.
Through parliamentary questions and annual reports, yes.
There is a note here at the very end that feels very current. It says, Gov presently taking disinvestment policy in public companies.
This is the shifting sand of administrative law. For 50 years, the model was the state running these giants. Now we are seeing privatization. When you sell off an entity like Air India, you are moving it out of the realm of state and into the realm of private market.
Which changes the rules completely. You can't use a writ petition against a private company the same way you can against the state.
Exactly. The machinery we've been talking about, administrative law, applies less and less as the state shrinks its economic footprint.
So, stepping back, we've covered a lot of ground. We've gone from fake porters to environmental fines. How do we synthesize this for the listener?
I think the synthesis is that administrative law is a system of friction. It's designed to manage the friction between a powerful state and a vulnerable citizen. Estoppel is there to stop the state from tricking you. Tribunals are there because the state is too big and slow for regular courts. Commissions are there because sometimes the state needs to investigate itself, even if it lacks the will to punish.
It's a complex ecosystem, and it leads me to a thought I want to leave our listeners with today. We talked about the Kizwaram case, where the government broke a promise because it was in the public interest.
Right.
And we accept that. We say the government needs flexibility. But consider this. If you, as a citizen, promise to pay your taxes, you can't back out just because it's no longer in your personal interest.
That's a sharp observation. The playing field is inherently tilted. The state creates the rules, and it also creates the exceptions for itself.
And regarding tribunals, we celebrate them for being speedy and skipping the strict civil procedure code. But when we strip away those boring procedures in the name of efficiency, what are we losing? Is fast justice always good justice?
Or are we just making it easier for the state to clear its desk? That is the eternal question. Efficiency versus safeguards. We haven't solved it yet, but understanding the system is the first step to navigating it.
Something to think about the next time you see a headline about a commission report or a tribunal ruling. It's not just legalese, it's the operating system of your life. Thanks for walking us through the code.
My pleasure.
And thank you for listening. We'll catch you on the next deep dive.